Good morning. I'm Jim Kovaleski. I'm an attorney with O'Donnell Weiss Mattei, with law offices in both Phoenixville and Pottstown. I'm joined by another attorney in the office, Rebecca Hobbs.
Good morning.
And we are going to be talking a little bit about estate planning, pretty timely given some recent deaths, particularly with Aretha Franklin, who died without estate planning, and now there's going to be most likely a lot of controversy involved in her estate. So I know when I think of estate planning, I start with some basic documents. I don't know if you are the same way, Rebecca.
Yeah, I am. So, whenever I'm explaining estate planning to a client, really I say there's three basic documents that everyone should have if they're over the age of 18. And those are kind of the building blocks for everyone's estate planning. And those three documents there's two that are considered effective during your life, and those documents are a financial power of attorney, a healthcare power of attorney with a living will, which is your advance directive, and also a last will and testament. So to kind of explain all three of those documents and how they work, the financial power of attorney, that document, like I said in the beginning, is effective during your life. And why that document is so important is it is appointing an individual, an agent of your choice, to step into your shoes and handle your finances for you during your life. And that's so important because, anything can happen. You can get into a car accident, you can develop an illness where you're still alive but maybe unable to manage those day-to-day financial tasks. And that financial power of attorney would allow somebody to step in and help you do those without needing to petition for a guardianship. And the other document, which is the healthcare power of attorney, that document is also effective during your life, and it is appointing an agent to make decisions regarding your health for you. And that document, a little bit different than the financial, because the healthcare power of attorney is effective only when you're not able to communicate or understand. So as long as you can tell the doctors and you can tell everyone what you want to have happen with regard to your health care, then you control those decisions. And that healthcare power of attorney is there in the event that you're not able to do that for yourself. Again, getting rid of the need to petition for guardianship.
So a couple questions, ones that I always seem to run into. Probably the biggest one is, I'm married. Do I really need these documents? My spouse can just do these without these documents, can't she?
Yeah, so that's a common misconception. So your spouse, if you own assets jointly, so let's say you have a joint bank account, then often your spouse is going to be able to transact on that account because they're on the account as a joint owner. Where you're going to run into some roadblocks are with assets such as retirement accounts. Or assets that you have in your sole name, even life insurance or annuities. It also can be really important for real estate. So even if you own real estate jointly, if you were unable to sign a deed, if your spouse wanted to sell that property, they're going to need a power of attorney to be able to sign your interests. So,
great answer. One of the other questions I often get with regard to the healthcare power of attorney is, what happens if my agent says that I shouldn't receive this treatment, but I'm telling the doctor that I want to have this treatment? What happens? How does that play out?
Yeah, so the important thing is capacity. So with a healthcare power of attorney document, we all have a right called the right of self-determination. So that means we get to determine what happens with our bodies. And as long as we have the capacity to make those decisions, then our decision rules. So regardless of what our family wants, we get to decide what we want. It's only where you lack capacity to make those decisions that the healthcare power of attorney would step in and be able to make decisions for you.
And who makes that decision with regard to the capacity? Is it the agent or is it someone else?
Yeah, so it's actually a medical determination for the healthcare power of attorney. So when the doctors determine that you're no longer able to understand or communicate the decisions that you want, then the doctors would say, okay, at this point, the healthcare agent can step in and make those decisions for you.
Great. Those two documents are very important. As you said, they're only for us. They only are effective while we're alive, but they allow someone to help take care of us if something happens to us while we're still alive. So very important, very, very important. I would even argue maybe as important or maybe even more important than the will, which is what we're going to talk about next. So when we pass away, those powers of attorney pass away. So then what's the controlling document at that point, Rebecca?
Yeah, so when you have passed away, that is where your last will and testament is going to be such an important document. And a lot of people know what a will is, which basically a will is explaining what you want to have happen with all your stuff when you pass away. So where do you want your assets to go? But it also has some other really important components to it. So one of those components is appointing an executor, which is an agent, a fiduciary that can manage your estate, liquidate your assets, pay final expenses, and then distribute your estate according to that last will and testament. The will is also important for other things. So for young couples or a young parent who has a minor child, that will is so important because you can appoint a guardian for your minor children in the event something would happen to you and there's not a natural parent that can step in and take custody of the child. So that guardianship can be really important where you have minor children. The other thing that the last will and testament is really important for is explaining, if you have minor children, again, not only the guardianship, but what would happen to the assets that you want to leave them, so you can establish terms under which they would inherit those assets, such as a minor's trust.
Great. Couple follow-up questions. Same one as before. One of the biggest questions I get is, hey, I'm married. I don't need a will because, again, my spouse will just, under the law, automatically receive everything in my estate. So why should I take the time to write it down? I don't need a will because of that.
Right. And again, it goes back to this how are assets owned question. So a will controls assets that are in an individual's sole name. So we call those probate assets that don't have a beneficiary designation. So where you have a spouse, where you're married, the will could still be really important, especially if you own assets that are in your own name without a beneficiary designation. But the will is so important for other reasons, which I mentioned with the guardianship and trusts. So with a spouse where most assets tend to be jointly held, then those assets are going to pass outside of the will. However, you still want to have that will in place because we never know what's going to happen. And in the event you and your spouse would pass away together at the same time as a result of a common, accident or disaster, you want to make sure you have provisions in there regarding what would happen there. Also, where you do own assets in your sole name and you don't have a will, Pennsylvania has an intestate statute where it explains what happens to your assets. And a lot of people think, well, it's just going to say everything goes to my spouse, so I don't need a will. And that's not true. So Pennsylvania says that a certain amount of the estate would go outright to the spouse, but then half of the estate actually passes to the children, where all of the children are children of both spouses. And then the other half would go to the spouse. So where you have minor children, it can get really tricky.
Absolutely. So all the more reason to have a will, which spells out specifically where the property is going to go, who's going to get what, when they're going to get it, if you have minor children and you decide to have a trust. One of the other things you mentioned is beneficiary designations. But I don't have to worry about those now because I've done my will, right? I mean, the will trumps all, so why should I be even paying attention to those beneficiary designations I did 10 years ago, 20 years ago?
Yeah, so those beneficiary designations are important because, like I explained, with what assets pass under the will versus what assets don't. And assets that have a beneficiary designation will pass according to that beneficiary designation. So they pass by contract. So you want to make sure that your overall estate plan coordinates. So you want to make sure that your last will and testament coordinates with your beneficiary designations. So that way everything is passing according to your wishes. The will does not override beneficiary designations. That's a very common misconception. So that's why you want to make sure that you check those and make sure that you've updated them. And it's advisable, especially with retirement assets, to make sure you do have beneficiary designations listed on that and they don't pass through the estate.
So I think what I've learned over the last couple minutes is that even what we call simple estate planning may not be so simple. There may be some issues that you need to take advantage of or question about, and make sure you plan accordingly. So I hope that hope the message has been delivered. I hope you have. If you have any questions, feel free to reach out to one of the attorneys here at O'Donnell Weiss Matei. Again, I'm Jim Kovaleski, joined by Rebecca Hobbs, two of the attorneys in the estate planning department here. Again, brought to you by OWM with offices in both Phoenixville and Pottstown. Thank you.